may have the courage to look up.
We've had triumphs, made some mistakes.
The Supreme Court is the highest court in the United States. As such, it is the final arbiter of constitutional questions, the court of last resort for those wishing to assert or protect their civil rights and liberties. Its job is to interpret a 200-year-old document and apply it to the issues that arise in a society which changes more rapidly than the framers of the Constitution could ever have envisioned. Perhaps no other governmental institution in America is simultaneously so idealized and so criticized as the Supreme Court. Idealized by those who believe it should be above the fray of politics, criticized by those who feel it interprets the Constitution with too little or too much latitude. Since the words of the Constitution never change, one might think the decisions of the Supreme Court would be consistent over time, unchanging, impervious to the political winds of the times.
Human beings have to be able to admit that they were wrong, and sometimes they just were wrong, and they realize the error of their ways, sometimes quite quickly. A few years later, they just say, this isn't working, we thought it would work, but it isn't working, and we're going to change our minds about it. Sometimes it takes a century, as it did over segregation. And of course, our societal norms are reflected in the people who sit on the Supreme Court. So when society changes, eventually the court changes in its views also. The Warren Court, after all, considered a very liberal court, was consistently upholding laws that differentiated in their treatment of men and women. It really wasn't for another 20 years that the Supreme Court got very aggressive about saying you have to treat men and women equally. And it was a much less liberal court in terms of the law that did that, but society had changed. Government had changed, people had changed, and the court came to grips with that.
The political environment of the Supreme Court affects it in several different ways, but we can think about two ways in particular. One is the general social climate. There are certain decisions that would be impossible during a given era just because there's not much support for them. The Supreme Court could not go back to Plessy versus Ferguson and say that it's acceptable to segregate the races, just because there's so little support in American society for that. That's one way in which the court feels and responds to pressure. Another way is that sometimes there are much more specific political pressures on it. During the 1930s, after the Supreme Court had struck down most of President Roosevelt's New Deal program, there was a feeling that that had created an intolerable conflict, and the court virtually had to retreat, and it did.
United States presidents may serve no more than 8 years, but a Supreme Court justice is appointed for life, and many serve for 20 years or more.
Upon Justice Rehnquist's confirmation, I intend to nominate Antonin Scalia, currently a judge of the United States Court of Appeals.
Perhaps a president's greatest chance to leave a political legacy is in the appointment of Supreme Court justices. Their decisions can alter the social and political landscape for generations.
I think you'd have to say that the Reagan-Bush justices, by and large, have moved the court significantly to the right, so that a justice who was considered sort of slightly center-right 10 or 15 years ago would today be considered on the far left of the court. I'm thinking, for example, of Justice Stevens, a Ford nominee. And similarly, the Clinton nominees, who are now considered on the so-called liberal end of the court, would have 10 or 15 years ago been considered center-right. There is no left on the Supreme Court.
The political ramifications of a Supreme Court nomination were powerfully illustrated by President Reagan's nomination of Robert Bork in the 1980s.
His appointment would have tipped the balance on the court from sort of moderate center to distinctly to the right. The Democrats had, up until that point, rejected nominees only on the basis of some sort of wrongdoing or lack of qualification or misrepresentation. And that was sort of the ethos of the confirmation battles.
Now, my question is...
The Bork nomination changed all that, in terms of the Supreme Court anyway, because it was the first time in the modern era anyway that a nominee was opposed for purely ideological reasons.
Presidents may nominate Supreme Court justices for political reasons, but once a justice is appointed to the Supreme Court, they are largely protected from political obligations and may vote however they see fit.
You have a conservative president, let's say like Ronald Reagan, who appoints someone like Justice Scalia, who he's known to be a conservative ideologue. That's going to have an effect on the court. By the same token, you take Bush, who appointed Clarence Thomas, who also was known as a conservative ideologue. It doesn't always work out, however, the way the presidents would like it. Bush also appointed David Souter to the court. And Souter was an unknown when he came on the court and has actually been quite a surprise in terms of his moderate to liberal jurisprudence.
The Supreme Court is far more independent of the politics around it than most other institutions of government. It not only has the aura of being a court, but practically speaking, probably more important is that the justices hold their positions for life, and there's nowhere higher they can go. They don't have to angle for promotions. That's not the same thing as saying that there are no pressures on them.
Although the job of a Supreme Court justice is to rule impartially, they, like anyone else, have personal beliefs and philosophies which bias their judgment.
Judges' philosophies are formed pretty much like the rest of us. Influences in the family, teachers, their reading, their education, work experience, people they meet at work, things they do at work. You take somebody like Chief Justice Rehnquist. His parents were quite conservative politically, and I think it's fair to say that he was very much influenced by his parents and his environment. He grew up in suburban Milwaukee. On the other hand, someone like Justice Brennan, great liberal justice, grew up in Newark. His parents were immigrants from Ireland, and he had to work very hard from a very early stage in his life, and he developed a expansive liberal philosophy.
Not only are Supreme Court justices subject to their own preconceptions, but their attitudes or philosophies may change during their tenure on the Supreme Court.
Justice Harry Blackmun, for example, was considered a moderate Republican judge when Richard Nixon appointed him to the Supreme Court. And of course, Blackmun wrote the court decision in Roe v. Wade, which was a very controversial and very liberal decision. And indeed, in most of his decisions toward the end of his tenure on the court, he was thought to be one of the court's great liberals. You can go the other way, too. Someone like Justice Byron White, who was in the Civil Rights Division under President John Kennedy, was thought to be, he would be a liberal on the court, but shortly after Kennedy appointed him to the court, White became an extremely conservative in areas certainly of criminal law and procedure.
Supreme Court cases often deal with complex and arcane questions of constitutional law. But the decisions handed down by the Supreme Court are more than just content for law books. They affect the lives of ordinary Americans in profound ways.
It would not be difficult to provide a long list of cases in which the Supreme Court has had a good deal of impact on American life. Brown versus Board of Education, not only for what it did directly in requiring the desegregation of schools, but for its broader effect on civil rights. Roe versus Wade, its impact on abortion. The recent decisions on the right to die, or more precisely, physician-assisted suicide, are going to have a good deal to do with the power of the states to control those kinds of practices. One of the things that is striking about the Supreme Court is how regularly it makes those kinds of decisions that have a good deal of impact on the lives of many people.
Does the Supreme Court simply interpret the law, or does it make policy? The question is almost as old as the Supreme Court itself and just as complex.
Not only do its decisions constitute policy in the sense that they're important, authoritative rules, but since the court always has choices, since the law leaves room for alternative decisions, they have to exercise a discretionary policymaking function. There's no way around it.
What is judicial activism? It's defined many ways. A judge that forces a state government to raise taxes. A judge, as in California, that overturned an election of the voters on affirmative action. A judge in Texas that takes over an entire state penal system. Those are all activism. I think the Supreme Court, in the decision of Roe v. Wade, is a great example of judicial activism. They legislated the right to an abortion, something that the Congress of the United States should be doing. I feel very strongly that Congress has a responsibility given to it by the Constitution to oversee not only what the judiciary is doing, but also the executive branch. That's what they're there for, to make sure that the judiciary does what the Constitution says it's supposed to do. That's interpret the Constitution and not implement it and not legislate. But we've allowed them to do it for a long time now.
The court inevitably is going to make policy, and like everybody else in government, their policies will plead one side more than they please the other.
As the Supreme Court has swung to the right, many of its decisions have begun to reverse or restrict the expansive interpretations of civil rights and liberties passed down by earlier courts. Bush versus Vera was a suit brought by plaintiffs protesting majority-minority congressional districts drawn in Texas after the 1990 census. The plaintiffs argued that the voting districts were unconstitutional because they were drawn primarily with the intent of creating districts which would have a majority of minority voters. Defendants argued that this was precisely what the Voting Rights Act permitted and in fact required. Defendants also claimed that the districts were drawn to protect incumbents.
Although gerrymandering has always been a major part of redistricting, it suddenly became something wrong when it was when that process was being used so they could elect minorities. We followed the Voting Rights Act to the letter, and I think that's why we could defend the district. It is simply a change in the direction of justice by who is on the Supreme Court and also the lower courts now.
The plaintiffs say the new districts group people by neighborhood instead of race, and that such a grouping makes for a better system.
No longer will the legislature be allowed to segregate and classify we voters on the basis of race, house by house, block by block.
Bush v. Vera is a good example of the Rehnquist court cutting back on what we would call civil rights and liberties, in the sense that instead of encouraging race-conscious programs, whether it be federal highway programs or redistricting in which to try to make up for past discrimination against racial minorities, the court has scrutinized these programs extremely carefully and for the most part has found them unconstitutional. This is not something that the previous courts had done or I think would have done.
Everybody agrees that if the lines were drawn in such a way that they were intended and had the effect of limiting the number of African Americans who were elected to the House, that would constitute discrimination in violation of the Constitution. The much tougher question is whether if a state legislature, in trying to further the goal of equality, draws lines in order to maximize the number of African American representatives, whether that constitutes discrimination in violation of the Constitution. And the Supreme Court, closely divided, held that it did violate the Constitution.
In Bush v. Vera, the breakdown of the justices was quite predictable in the sense there is a philosophical split between the 5 members of the majority and the 4 in the minority. Now, there are additional breakdowns within the majority and the minority. The opinion was written by Justice O'Connor, who tends to be a moderate conservative and decides each case on the facts without getting into any broad philosophical view.
Significant deviations from traditional districting principles, such as the bizarre shape and non-compactness demonstrated by the districts here, cause constitutional harm insofar as they convey the message that political identity is, or should be, predominantly racial.
There are more conservative members of that majority, Justices Scalia and Thomas, for example, who say that any consideration of race triggers a strict scrutiny, and in their view, they've never seen a race-conscious program that they're going to find constitutional. In the minority, you have people like Justices Stevens and Justice Souter, Ginsburg, and Breyer. They feel that there's a difference between invidious discrimination and affirmative action, where you're trying to make up for past discrimination. And they said that the 14th Amendment, in fact, was intended to give racial minorities first-class citizenship. And now, ironically, they argue, the court is going out of its way to prevent this kind of affirmative redistricting plan.
When the Supreme Court struck down the redistricting plan, candidates suddenly had to campaign in new territory.
I had less than 90 days to get to know about a 46% new district, and primarily people that I'd never represented before, and also had been in a district that was represented by Dick Armey, who was pretty philosophically, or at least ideologically, different than me, and very different than what the total district would consider good representation.
It affected the people very hard. They were angry, they was in disillusion, they were thinking that we were without representation. And when I say representation, I know we have people as all colors to represent people, but this was the first time we had had a black person in a long time. We had a representative before Eddie Bernice, but all of them has been Republican, and we are a Democratic area and going to stay a Democratic area.
If you look at the voting patterns, it falls off tremendously when they feel that there's no one that they identify with that they can vote for. And that is clearly very important in our system of justice. This is America, and we're supposed to be able to exercise our right to vote for persons of our choice. And there are many islands where minorities feel very used. I have been told many, many times over that they feel responsible for having put someone in Congress, have been leaned on and depended on for their votes, but never seem to be noticed once the person's there. And that's a very, very prevalent feeling among minority voters.
Equal protection of the laws was the issue in another controversial case that came before the Supreme Court.
Trying to tell the wicked to repent of their wicked way.
This time, the question was, can the state of Colorado pass a law which denies special protection to gays and lesbians?
We cannot in our society tolerate a slur against people who are gay or people who are lesbian.
Colorado's Amendment 2 roused Americans on both sides of the issue and was a watershed case for gay and lesbian civil rights advocates.
The purveyors of that law said, we want to undo some hard-won little laws that got passed in a number of municipalities in the state of Colorado, including communities like Aspen and Denver and Boulder. those laws passed by usually city governments said you cannot discriminate against gay citizens within our city borders in a number of transactions, from housing to public accommodation. Amendment 2 would have undone all those laws, but it would have gone further. It would say that no one who is gay, lesbian, or bisexual who lives in Colorado and who are residents or citizens can seek redress or any kind of protection from any legislature from now and forever.
The Christian Legal Society felt that Amendment 2 was a perfectly valid means for the majority of Coloradans to decide that while homosexuals in their state would be protected by all the laws that protect you and me, all the general anti-discrimination laws on the basis of race and age and sex and disability, what have you, that, however, they would not be given special protected status, city to city, county to county, but rather would enjoy the protections that all the rest of Coloradans do, no more, no less.
As usual, the Supreme Court vote was split between conservatives and liberals. Strongly divided, the justices of the Supreme Court saw the issue in very different ways.
I think with Romer v. Evans, the most conservative members of the court, that is Chief Justice Rehnquist and Justices Scalia and Thomas, were predictably going to uphold the amendment. They are very, very wary of creating a new civil liberties precedent for minorities, and certainly not for gay and lesbian minorities.
The constitutional amendment before us here is not the manifestation of a desire to harm homosexuals, but is rather a modest attempt by seemingly tolerant Coloradans to preserve traditional sexual mores against the efforts of a politically powerful minority.
The liberal moderates on the court, that is Justices Stevens, Souter, Ginsburg, and Breyer, I think would also be predictably more receptive to the argument by the gay and lesbians that their rights under the Equal Protection Clause of the 14th Amendment had been violated by this amendment, which prevented protection for gays and lesbians. So then the decision comes down to the two moderate conservative swing votes, that is Justices O'Connor and Kennedy. Kennedy wrote the majority opinion, and I think he surprised everybody, both conservatives and liberals, with the sweep of his opinion.
We find nothing special in the protections Amendment 2 withholds. These are protections taken for granted by most people, either because they already have them or do not need them. We must conclude that Amendment 2 classifies homosexuals, not to further a proper legislative end, but to make them unequal to everyone else. This, Colorado cannot do. A state cannot so deem a class of persons a stranger to its laws.
And what was very elegant and charming and noble about the majority opinion is that this is the kind of idealistic language that you can see around the turn of the century and again in the 1960s.
The idea that the people of a state may not amend their own constitution to for interests of protecting religious liberty or other legitimate interests, in order to, because it disfavors a particular group, really calls into question an earlier decision of the same court in Bowers versus Hardwick that said that a state may criminalize that conduct.
There was a gay rights case, a case from Georgia, Bowers versus Hardwick, in which the court, by a 5-4 vote, upheld an anti-sodomy law applied to homosexuals and said the state was within its rights to ban as criminal private sexual activity among consenting adults in the privacy of their home. Now, interestingly, in the Colorado case, the court never even mentioned its previous ruling in the Georgia case. And there's obviously a reason for that. It didn't want to deal with it, and it probably represents not only a change in the membership of the court, but also a change in society's views of homosexuals.
What's important to know is that today, the gay and lesbian movement in America is at about 1961, if you compare it to the Black Civil Rights Movement. Romer versus Evans is like the gay Brown versus Board of Education.
That decision is so broad and it plows such horrendous new legal authority that it almost strips from the people the right to order their state, their conduct, in a manner that preserves traditional morality. Now, I thought that in this society, the majority were allowed to do that as long as they did not drop below the floor that the Bill of Rights provides for us. And last time I checked, the homosexual behavior was not a fundamental right.
Had that been allowed to stand as a matter of law, as a matter of constitutional law from the U.S. Supreme Court, it would have taken an entire group of Americans and arrested them in their tracks.
When the people want to do something I can't find anything in the Constitution expressly forbidding them to do, I say, whether I like it or not, God damn it, let them do it.
The Supreme Court does not operate in a vacuum. Political and ideological trends, personal attitudes and preferences, and the needs and expectations of ordinary citizens all find their way into the closed chambers where 9 justices deliberate and decide on the fate of America's laws and of its people.
In the United States as elsewhere, we tend to think of the courts as being separate from the rest of government, as being separate from politics. They are not. This does not mean that judges are exactly the same as presidents or members of Congress or governors or other political officials. There are differences, and there are differences between courts and other institutions. But courts inevitably make policy, judges inevitably have discretion about the choices they make, and because what they do is important, they're inevitably part of politics. And so it's far more useful to think of the Supreme Court and other courts as being enmeshed in the political process than to think of them as being separate.